Well, thank you all for joining us today for the Creative Finance Collective. I'm here with Drew Jenkins today. As you may notice, my law partner, Andy Fowler, is not with us today. He is off getting some much needed rest. He's, unavailable, which is good. He's taken some time away. I actually hosted the In-Rim podcast this morning by myself, which is the first time that I did that. And I will tell you, I am ready for Andy to be back because it's difficult to be a solo host. Andy kind of drives the show and I kind of sit in the background and chime in here or there. And my life's pretty easy. But so I know what he goes through every week and appreciate that. But if you're new joining us, please go to our YouTube page, In-Rim Podcast, like that. Go to our Facebook page, like our In-Rim Facebook page. But basically the way this is structured and set up is Drew and I are going to be here. We may chat a little bit while some questions are posted, but basically this is your opportunity to post questions and we will respond to those questions. Basically anything real estate, creative finance, real estate transaction related, even, we can get into some litigation stuff here or there. But if you have questions that touch on real estate that you think we might be able to assist with, we are more than happy to look at those questions and provide some feedback. But if we don't have questions, then it might be a short night and Drew and I will get on with our evening. So, So Drew, how's it going? I can't hear you again.
There we go. Always something, huh?
Oh yeah, there we go.
Picking up quite a bit. Picked up a lot more commercial files recently, so that end of the market seems to be on the upswing again. A lot of development coming back into play with everyone. So things are going well. We keep expanding. Hired some more folks to help us out over here. So all in all, everything seems to be moving in the right direction after everybody got over the holidays.
Yeah, growing. That's important. That's exciting. And I too have noticed a little bit of pickup. I do some commercial transactions here or there, and I basically in a span of about a week did two, pretty decent sized PSAs that should go to escrow on both of them. So yeah, it's interesting how or why things like that are picking up, but it's good for the market.
Yeah, and in the broader base of things, we're seeing more multifamily coming on for sale as well, right? Because obviously, as people's rates are expiring when their loans mature, when you borrow it for basically nothing and you're having to refi, depending on your strength as a borrower, from like 6 to 8%. I think we spoke about this last week as well. As the hot thing that I have a file right now is we're trying to assume agency debt at like 5.25%, a Fannie Mae small business loan on this multifamily. And I mean, assumable agency debt is really, really, really attractive if you can pull it off.
Right. Yeah. No, it's complicated, but if you can dial in those assignments and accomplish them, that's huge. Then you don't have to be, or assumptions, you don't have to really be worrying about due on sale and otherwise, because the lender is signed off and giving you that approval, right?
Correct. Now, one thing that we did run into that I didn't anticipate was, my client was planning on throwing a second on it, right? Because obviously, the agency debt, your LTV is, I think, like 50 something percent at this point, because it does have an AM schedule on it. And so, he thought he was going to bring in a second to help lower his equity injection, his down payment. But the agencies won't allow anyone to carry a second. I think we discussed that last week, because they're kind of worried if you don't have enough skin in the game. But still, I mean, that turns, if you're going to buy this thing, you better have 7 figures cash,
right,
in order to take down that equity injection, which is pretty dear. So this is kind of creative. So what he's doing in this case is he has his main lender and he is going to collateralize other properties that he owns,
yeah,
with a line of credit to draw against. So he can then make this, seven-figure equity injection to assume the agency debt, because the spread, his bank would be like, look, I can give you a loan for 8.5% with a 20-year AM schedule on it, when he could assume a agency debt that still has 25 years left on it at 5.25. So we have to get a little creative. Obviously, we worked it into our contract. It's not a contingency, but it is something that everyone's aware of. Is, hey, we're acquiring this loan on unrelated property in order to make
Right.
the equity injection necessary to pull this off. So creative in a different context to what
Yeah,
we're
and
normally
that makes
talking
sense.
about.
I mean, if they don't want the loan secured by the actual property, I mean, depending on what the loan documents state, um, you have the ability to go and get financing through other
Right.
collateral, which
And in
makes
fact,
sense.
I used to see that in Alabama, and I don't, I guess because of rates, it's no longer a very popular strategy. But a lot of people that were getting started, right? They might already have somewhere between 5 to 20 homes. And in fact, I just had a client that cashed out 21 of his properties last year, to bring in just shy of $1 million worth of loan funds. And of course, he's able to compete really well in the market because he always walks in as a cash buyer. Right?
Right.
Even though he's
Yeah.
not really a cash buyer, he's a cash buyer, right? And so then what they do is, they'll use all that cash to go be a cash buyer. And once they get another 4 or 5 properties, they'll just collateralize those, to increase their line of credit. And they're just continually drawing against it as a way, to compete in the market because there's no financing contingency, which I think is a smart
Right.
way
No,
to.
that makes sense. I mean, that is a good strategy where you basically can go and you close, and then a lot of people will have good relationships with like small community banks. So you compete and you close, and then those banks know you, and then you go to them and say, okay, I'm ready to refinance and pull cash
Right.
out.
And one thing
Uh,
that I've seen, and I thought this was really clever, and so anyone listening, this is I don't know why I didn't think to bring it up sooner, is if you buy a property for cash, there are some lenders that will require a seasoning period, right? So if you buy it cash, they're going to make
right.
you wait 6 months before they will allow you to cash out, refi basically, or do anything. So I have had 2 clients in the past that took out loans. I mean, they're legitimate loans, but the whole purpose of taking out this loan was simply so they could immediately refi it into more conventional or traditional financing. And everyone knew what the game was. So it's a hard money lender that knew they were being taken out in the span of like 30 days, because the whole point of them being in this deal was so that they could immediately refinance into lower rates, right? They had the cash to pay for it up front, but
Right.
again, the bank that they generally like to borrow from had seasoning requirements. And so by turning it into a loan deal with hard money that obviously, they can close in 2 days, if you're good at it, they were able to not have to wait 6 months to get their money out at a lower rate.
What if, let's say I have cash and I throw it into like an LLC that I have or I control, and then I legitimately make a loan to myself and secure that loan against the property? Can I do a cash out refinance, or will the bank not like that? Like,
So the bank will not know. I may or may not have had a client in the past that, operated under this exact same strategy. So when it comes to payoff lenders, right, the banks, they don't actually know, they don't actually care. All they see is that someone made a loan on the property. And you're right, it's fully buttoned up with the promissory note, your deed of trust slash mortgage
right.
slash security
It's
deed.
legit. It's
Yeah,
a loan.
it's a real loan from
Yeah.
one LLC to another, right? The fact that they happen
Right.
to have overlapping ownership is of no consequence. Yeah, and
Interesting.
so that.
So that's another strategy, right? If you pull out on an equity line on another house and you want to basically pay that equity line off by, because equity line rates tend to be higher, right? You want to pay that line off through more traditional, but you want to be competitive in the market, you throw cash down. Obviously, consult with an attorney in whatever state you're operating and make sure that, everything is I's are dotted and T's are crossed or whatever. But, in theory, you could potentially be your own lender. Now, if you're ever asked by the bank that you're getting the loan from, like, do you have this, who's the lender on this other loan? Then, or who owns this other LLC that, provide the funding, you might have to disclose that.
Yeah, don't ever lie to your lenders,
That's
right? I mean, it said don't ever lie to your lenders.
right. Never lie to your lenders. And that's the thing, right? Never, yeah. If a lender asks you a question, you answer that question, or you say you're not going to answer it, but you can't
Yeah,
lie.
and I promise you, the lenders know what you're doing. So obviously in double escrow transactions, right? Sometimes I'll get the parties are like, well, on the commitment, we needed to show that we're the owner. Well, how, or another question I get, especially from new people is, well, how is the bank going to know it's a double escrow? Well, the bank's going to know it's a double escrow because they're going to get a title commitment that shows that the seller's not the owner, right? Like
Right.
lenders actually read their documents and they're not stupid. So, when you're trying to
Right.
play these games of playing hide the ball with your lender,
Yeah.
that's not a good strategy. Right? You need to
Right.
find a lender that's
Yeah.
willing to play ball with you rather than trying to pull a fast one on your lender because there's a very good chance it's not going to work. And title shouldn't be helping you on that because very often we get requests to say, well, hey, can you show it vested a certain way? And the answer is, unfortunately, no. A title
Mm.
commitment is a statement of title as of the effective date, right? I get that there are
Right.
other things occurring after the effective date, but I can't have my commitment reflect that because it's a statement of the past. As of a certain date, this is what title looks like, and I'm willing to insure based on that. I can't just make changes because you need it to show a different person. I mean, we get those requests somewhat frequently, or even a lender will say, hey, we need you to show X a certain way. And I just got it the other day. Hey, well, our borrower is a single man and, you're showing, husband and wife. And I'm like, yeah, because there's a deed and record that says husband and wife co-owned, right? You're going to have to do a QCD. And the lender's like, well, can you
Right.
prepare that QCD for us? And the answer is, of course, yes, we can.
Right. For those watching, QCD means quick claim deed, right?
Yes.
Yeah.
Yeah, it's just to switch it up. And I learned something kind of important the other day, and this was talking about having entities that are related to each other. Is, when do you normally see QCDs? Like, I know different states have different rules regarding them. In Georgia, they're not really a problem. They have some quirks, but they're effective at transferring whatever you
Yeah.
own. How is it in Wisconsin and out in Arizona?
Wisconsin, I'm not sure. I haven't had enough experience with them, but in Arizona, they are disfavored. Title companies hate them. They don't want to insure on them. So in that hypothetical where you were talking about the husband and wife scenario where you're going to need a quick claim deed from, say the wife to the husband, we would do what's called a disclaimer deed. So the wife would then disclaim, or well, we would do two documents. We would do a warranty deed from the wife to the husband, and then we would do a disclaimer deed whereby the wife is disclaiming all of her community property interest in the property. That's what we would do. So we would move title into the name of the husband by a warranty deed, and then we would do a disclaimer deed on top of it just to make sure that there's no, lingering community property interest that's not taken care of via the warranty deed.
Got it. So one area here that you generally see QCDs fairly regular is on intercompany transfers, right? So you have a developer with all these subsidiaries and affiliates, and you're needing to move property between them. So we used to do quick claim deeds because that's what everyone is used to. It's quick and easy. Now, of course, a warranty deed is just quick and easy. And then I learned something rather important, probably about a year or two ago is in a quick claim deed obviously carries no warranties, right? Whatever I own, you got, but if I don't got nothing, neither do you. That's the function of it.
Right.
So what that means is if there's a problem in title, the transferee has no recourse against the transferor, right? It's bought, it's like going and buying a car without a warranty. So, but if we transfer it with a warranty deed, or depending on your jurisdiction, a full warranty deed or a general warranty deed, the title insurance does not transfer. But do you know what does transfer? The seller's obligation to convey clean title. So
Oh,
Exactly.
interesting.
And so remember, title insurance operates on a waterfall fashion. So when I turn around and I sue my grantor, right, or in this case, the affiliate, which is a separate LLC, because he's breached his full warranty to me. Now, obviously, if the grantor is the one that caused the title problem, there's no coverage. But if it turns out it was a pre-existing problem in the chain, then my grantor is going to turn around and file a claim on his title insurance, who is going to turn around and try and find their seller, right? And so you wind up, waterfalling it back up
Right.
until you can't find anyone anymore. And that's how title insurance actually works. So, rather than have, some of my developer clients, have to rebuy policies every time, or QCDs, and then they're kind of out of luck when there's an old problem in the chain. We'll just transfer it via warranty deed. Fortunately, we haven't had any issues, but it seems like a pretty good benefit to provide the client is to say, hey, take a warranty deed. And I don't know how it is in y'all's jurisdictions, but for example, in Alabama, most transfers are done via warranty deed, right? Full, general, whatever you want to call it, the whole thing. Anything that ever goes wrong, seller's going to make right, right? In Georgia, using the GAR form, it always specifies a limited warranty deed, which again is sometimes called a special warranty deed or a statutory warranty deed.
Yeah.
And so it's just
Mhm.
interesting to see the jurisdictional differences on warranties and conveyances.
Yeah, we normally, I mean, the standard is to do a special warranty deed for, most arm's length transactions. Which now that we're talking about it, maybe we should start doing special warranty deeds for all transfers. But in any event, we do special warranty. But what a lot of people don't understand with title insurance is the fact they think, oh, well, the title company will just cover it and everyone's happy. It's like, no, it doesn't work that way. Yeah, they'll cover it, but they're going to subrogate, which subrogate means they're going to take whatever claim their insured had against someone else, and they're going to assume that claim and they're going to pursue it to try to get recovery. So, just because title picks it up, that doesn't absolve the seller or the grantor from liability for the title problem that was conveyed over to the grantee, and that was insured. So, a lot of people don't realize that like, yeah, title insurance, they're looking to get their money back from somebody, and they're going to take it out of somebody's hide normally, and a lot of times that's the seller, or even like you said, even further back in the chain of title, depending on how the conveyances were done and what warranty deeds were used, or quitclaim deeds for that matter. So
Yeah. And yeah, I mean, you're right. A lot of people don't understand title. I had a lady call me today. She was upset about her property taxes. She got a bill for $710, and she wanted to know why I didn't pay it. And the answer is very simple. We closed before the bill was out. I didn't pay any property taxes for
right,
2023 because there was no bill available, right? We estimated
right,
based on the assessment. The assessment was out. We
yeah,
estimated based on the assessment. We told your
right,
lender, the estimated taxes based on the assessment. And the fact that they didn't collect enough to pay it in full at closing is not a title claim because that bill didn't exist until after we closed, right? Title only insures
right,
events
yeah,
prior to its effective date. And so,
correct. And they weren't liens at that point because they weren't even
yeah,
due
they
and
weren't,
owing.
I mean, they weren't even generated. So, and, she wanted to go
Right,
round and round with me over it. And it's like, and I had another lady do the same thing with like a municipal lien in Savannah or something. And it's like, you know, these things aren't really title issues. It sucks. You're out some money, but it's not at my
right,
level. And people think that title insurance, is insurance against everything, or it's regular insurance, protects against future events. And so it's something to get people
right.
to learn. One thing I did want to bring up today, though, is did you get a chance to
Yeah,
look up last time we mentioned briefly about the geographic targeting orders with FinCEN, right?
I
Right.
did
So
not.
we all know about the CTA, right? That wonderful Corporate Transparency
Right.
Act that now has that North Alabama case that says it's unconstitutional as to the
Yeah,
plaintiffs, not against everyone else, but just to the plaintiffs. And that
correct.
same group, FinCEN, is now, or the same government entity, FinCEN, is also wanting all cash real estate transactions just like with the CTA, all title writers, basically agents, are going to need to register transactions with the government. So it looks like they're applying the SAR sort of stuff. Are you familiar with suspicious activity reports under the BSA?
No, no.
So anytime you take out or you deposit $10,000 cash in a bank with,
Oh yeah, I'm
yeah.
familiar with
So
that.
basically they want that kind of filing on all cash transactions above a certain threshold nationwide.
What's the threshold
Well, it depends on the
for real
jurisdiction.
estate?
So let's look here. Uh, Purchasing threshold so currently, this was in 2022, FinCEN had one for New York, San Antonio, San Diego, San Francisco, and Seattle. They expanded it to DC, Northern Virginia, Maryland, and Hawaii and Connecticut. The purchase threshold was $300,000. So if you were buying for cash for $300,000, the title company was sending all your information to the government, telling them who you were and who the seller was and all this wonderful stuff. And however, with the exception of the city and county of Baltimore, the threshold is $50,000. So if you were involved in a cash transaction of $50K in the city and county of Baltimore, the Federal Financial Criminal Enforcement Network knows all about it. And they want to expand this framework nationwide.
That's such overreach. And the thing is, look, I mean, here's the thing, and this is even in my view, the problem with the CTA is these money launderers that they're trying to track down, they're either not going to register and still be mixed into the, whatever, 50 million or 5 million, there's more than 5 million, 50 million LLCs that exist out there. And they still are going to have to track them down. Or number two, they're going to register with legitimate people. Like, do you think Al Capone owned all of the entities that he was getting money from? No, right? I mean, you're not gonna have these money launderers all of a sudden be the front people, and so they're still going to do those commercial those cash transactions. They're just going to give legitimate information and have like straw buyers and stuff, and then they'll close, and guess what? They'll just deed it to some Wyoming LLC that nobody knows about.
Right. And they'll probably deed it after the fact for no consideration, which of course would be exempt.
Right. So, I mean, yeah, all it does is honestly punish and make life more difficult for the law-abiding citizens.
Well, it's going to raise costs because every time we have to file something, that's more time that we're not able to handle in our current files. And so, that increases our overhead. It's kind of like how people get mad at, going to the doctor. Well, how much billing time do they have with those insurance codes? Right? It's kind of getting to be the same thing. How many people do we have to have, and how much time do we spend, sending some information, but not everything to the government?
Yeah, we've more than doubled the price of our LLCs because of this, because we have to go and track down so much information from the client and make sure that the information that we do get it, like copies of driver's license and the whole thing. And if the entity is layered, we got to report for all the, other entities that are involved and the whole thing. It's a real process.
Right.
And so, we charge a lot more now.
They just said, I don't form the LLC, right? You go online, get it formed. I'll write your documents, right? I'll paper you over, but I'm not going to form it anymore.
The problem is how many times has this happened to you? Because it happens to me on the regular. My client forms the LLC. They come to me and they say, hey, so can you prepare the operating agreement? And this is how, these two companies are the members, and myself and so will be the managers, and blah, 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 right? And then you get in and you look and you're like, well, you formed it as a member managed entity and not a manager managed. And so if you want to set it up this way, we've got to go and do an amendment. Well, now we're back into FinCEN again, reporting. Or I've had it where they've, basically did it all backwards, where the members were the managers and the managers were the members, or they missed, they didn't list a member. Like, unfortunately, it does not get done correctly most of the time when I leave it to my clients to do it on their own. And so I like to form them, and plus that allows our firm to be the stat agent. And yeah, there's advantages with having that and whatever.
Well,
But
not only that, but even when you set it up right, it doesn't mean the client's going to do it right. I mean, I literally had a file last
correct,
week where it's one of these LLCs that creates a board of directors, and you have a managing director. And of course, it's a single member LLC, right? It's a guy that owns it, but he has a board of directors,
right,
and you have a managing director. And then, of course, he signs his documents as managing member. And of course, you have to point out to him, you don't have a managing member, right? You have a
right,
managing director on your board of directors, and you have presidents and secretaries and treasurers. You have all this fluff in this 30-page OA
right,
for a single member LLC, right? Just stop it. You're going to sign as sole member, right? I'm going to go straight to the top,
right.
and you're going to
Yes,
sign as sole member, and we're going to suspend your operating agreement for the purposes of this transaction and move them
right.
forward.
Yeah,
And I think people that are watching, if they go through this, you really need to think long and hard about your documents and how they're structured, because they absolutely can be a roadblock in getting transactions accomplished. And you're, through no fault of your own, you're totally ignorant on the fact that different types of entities may, in different states, have very different rules regarding your operations. A great example of this is in Georgia. In Georgia, corporations have to be signed by a president or vice president and must be attested by a secretary or vice secretary. So if you are the sole shareholder of a corporation, guess who has to sign twice?
yeah, I would. You do, right?
You. You're
Yeah,
going to sign as president, and
right,
you're going to sign again as secretary.
right.
It's silly, but that's the rule in our jurisdiction.
Well, where we've seen things kind of get a little off centered is dealing with like Wyoming and Delaware LLC. So people, we've had clients who they form an Arizona LLC with the Wyoming LLC being the member. And so we say, okay, do you have an operating agreement for the Arizona LLC? No. Okay. Uh, do you have an operating agreement for the Wyoming LLC? Well, no, but we want to close. And I say, you can't close because Wyoming and Delaware,
No,
by
I knew that.
operation of law, require an operating agreement for you to even have a valid LLC there. And so I don't even know who can sign the documents without an LLC from those states because they're anonymous states. So who do I even get to sign anything? So we need an operating agreement. And then I've had the client send me the unsigned operating agreement. How many times do you get the unsigned operating agreement in your closings?
In truth, probably 80% of the time, they got some document they found, and that's their operating agreement. So we just haven't signed at closing.
Right. Yeah,
And
that's good.
I had one of my larger clients. Again, he owns, I think, over 50 homes and multiple LLCs, and he has investors that cycle in and out, and he refis them out, that kind of thing. And the bank was like, we need an operating agreement. And they're like, hey, Drew, get this. So the bank kind of provided the OA, and they're like, get this signed at closing. It's like, okay.
Yeah, that's a good way around. Well, if you're just joining us, this is the Creative Finance Collective. Drew and I are just talking about some random real estate stuff, mainly real estate closings, title insurance, things like that. If you have questions, post them. If you don't, we'll probably be wrapping it up here in the next couple of minutes. So this is your chance. Post those questions. Otherwise, we're going to go on with our Tuesday evening, and we'll meet up again on next Tuesday when Andy's back in town. So
And you know what? I bet when Andy's back in town, like usual, we're going to be flooded with questions. It's the
yeah, I
fact that
don't know
he's
what it
not
is.
here.
Yeah,
Andy's the draw.
he is. Yeah, that'll make him feel good when I tell him, man, we didn't have any questions tonight on the collective. We needed you. So, yeah, I don't. So it looks like we don't have any questions tonight. So at this point, we'll probably call it, and we will meet up again hopefully next Tuesday.
Sounds great. And hopefully we'll have more people join us, not only with questions, but we'll have Andy back, and hopefully some of the
Yeah,
other guys will come in as well.
Sounds like a plan. All right, Drew, have a good night.
All right, you too.
All right, talk to you. Bye.
Bye, Sean.